really love helping small businesses avoid problems that can really cripple small businesses. So I wanted to talk about, I call it legal extortion, how to protect businesses from nuisance lawsuits. So I call it legal extortion, and I tell people all the time that they really make their living on the spread between what it will cost to settle a lawsuit for an employer versus what it will take to defend a lawsuit, even a successful one. And business people make prudent business decisions, and when faced with the lawsuit, they say, well, it'll cost me this much to settle it and that much to litigate it, and even if I win, I've still spent. And so they make their living on that spread. And so that's why I call it legal extortion, and I want to help businesses prevent that from happening. A few facts about why this is such a pernicious thing, these plaintiffs' attorneys. Our legal system is the most costly in the world. It costs about $100 billion, according to the US Chamber of Commerce. Twice that of the UK, 3 times higher than France, and 5 times higher than in Japan. 1 in 3 small businesses will have been sued or threatened with the lawsuit. Think about that. Of all the businesses in the country, 1 in 3 is threatened or actually sued. There's not that many Fair Labor Standards Act violations or sexual discrimination or religious discrimination or any of the, it's not that prevalent. So why is that? Because these people are making their spread on the difference between just the ability to file a lawsuit to get a payment. And of course, all these costs that you incur, you pass on to your customers in the form of higher insurance rates, in the form of higher, whatever it is you sell, you now have to cover the costs. So the best way to do this is to prevent them. The way to prevent these type of lawsuits is what I refer to as the bookends. So the first bookend on the front is pre-employment. And as you are hiring someone, you can, if they're an independent contractor, and I'll get into that in a second about what an independent contractor is, you can have them sign an independent contractor agreement that specifically says things like, you can't file a lawsuit, you have to go to arbitration. By law, you can't ask them to give up future claims, but you can get them to agree where those claims will be resolved in an arbitration proceeding as opposed to a litigation proceeding. If they're not an independent contractor, then an employment agreement. Yeah. So, independent contractors. I hear this all the time. Well, I don't have to worry about the Fair Labor Standards Act because I don't have employees. I pay them all 1099, so they're independent contractors. And I immediately go, oh my God, we have to have a talk, because you, as the employer, do not get to designate whether someone is an independent contractor or an employee, and you certainly don't get to do it simply by the method by which you pay them. Most important criteria is control. Do you tell this person when to come to work? Do you tell them how long they can stay there, when they can leave? Do you tell them how to do their job? Do you train them? Do you give them the tools to do their job? All of those things. If you do all of those things, they're an employee, not an independent contractor. So if you're telling somebody you have to be at work for this many hours, and they otherwise qualify for the FLSA, you're gonna have to pay them overtime, you're gonna have to comply with those statutes. And I have seen time and time again where someone says, oh, they're an independent contractor, yeah, they work more than 40 hours a week, but I pay them on a flat fee basis because they're an independent contractor. Well, the Fair Labor Standards Act is one of the most unfair statutes with respect to labor and employment that I think exists. So don't fall for the independent contractor trap. If they are an independent contractor, have them sign an independent contractor agreement that specifically says you are an independent contractor because I'm not controlling when you come and go to work, I'm not controlling how you do your job, I'm not doing any of these. And I draft these and I track these criteria, and then I tell the employer, make sure you follow this. You can't have them sign an agreement that says nobody's going to tell me what time to come to work and then tell them what time they have to come to work. You can make employees sign an employment agreement not only at the beginning or as they're being hired, but if you have had somebody that's working for you for 20 years as an at-will employee, you can tell them, guess what? You have to sign this or I'm going to take my property back. You can make employees sign an employment agreement at any time, even if, provided they don't have an employment contract. You can make them sign these agreements at any time, and I do that all the time for clients. I tell them, go into work, make every single one of your employees, whether they've been there a day or a year or 3 years, make them sign this. And by doing so, they protect themselves. So what I typically put in employment agreements, a non-compete agreement, non-solicitation, non-disclosure of trade secrets, and a dispute resolution policy. So that's the one bookend. Now we're at the other bookend, what I call the severance agreement. Now, what's important about a severance agreement, it's a contract just like any other contract, but you can't just have them sign a contract that says I'm going to give up any and all claims in exchange for my final paycheck. You have to give them something of value that they did not earn. That's the consideration, because if you make them sign a severance agreement but don't give them anything, it's not a valid binding contract. Give them anything of value, and you can't say that their final paycheck is anything of value because they're already entitled to that. So by giving them the final paycheck, you're not giving them anything of value in exchange for signing this agreement. So what I tell people all the time is make them sign a severance agreement, give them $1,000 on the way out, and they always bristle, this guy cost me this much money because he was a terrible salesman and I caught him smoking weed on the job and whatever, I've heard it all. Don't care. $500. Give him something. Give him 2 weeks pay. Give him something, or her, something of value that they did not earn in exchange for signing this severance agreement, because if they do, they've released the employer from any and all claims. So we don't even need the dispute resolution policy. We don't even need the binding mediation language. We don't need the arbitration agreement because they have signed a release that says there are no claims, and to the extent there are claims, I release the employer from them. So if you get a lawsuit a year later, I've seen that happen, that says Fair Labor Standards Act violation, we're suing you. I file a motion to dismiss with a copy of the severance agreement and say adios, and it's over before it began. That's how you avoid these lawsuits. So in conclusion, independent contractor when available, employment agreement if you don't have an independent, if it's not a bona fide independent contractor, include a dispute resolution policy and a severance agreement, and you have done what my religious discrimination client has done, which is you've essentially won the lawsuit before it's even been filed. Document everything. Every time you talk to the employer, write it down. You can pull out all the evidence and say, didn't you sign this acknowledging you were doing a bad job? Didn't you sign this acknowledging that if you didn't improve, we were going to fire you? Didn't you sign this saying that this is a valid, non-discriminatory basis for an employment action? Well, yeah, but, okay. Then you won. And you've won before it's even started.